Have the police arrested all the goons in this country who are killing people? Have the police arrested the people who are murdering people all over? Femicide is up. Now you know any injustice to one advocate is an injustice to all advocates. Any misbehavior now by public officers, the public officer will be sued by his name. So if Ndegwa goes, Ndegwa is likely to make 100 million. Because for advocates, it is an court officer. He's not a politician. It does not add mileage to him. It is diminishing the profile of advocates. So from court helicopter, we urge Ndegwa Njiru to proceed to seek for compensation of 100 million from the police officers who arrested him. Welcome to Court Helicopter Trending News. From Court Helicopter, I'm disgusted. I'm annoyed. It is not proper how a colleague of ours, Ndegwa Njiru, an advocate, a serious advocate, the man who argues his case like an alligator, an advocate with passion, an advocate with passion, an advocate with conviction, an advocate ready to defend his client's position, regardless of what the state happens. He was arrested and dragged to court. Has this ever happened? Yes. Bramwell was so mad. Our crew, he went to the judiciary library and got the case. This is the constitutional petition E273 of 2021. The judge is Anthony Murima J, Commissioner of the JSC. This is a judgment he gave in December 15, 2025. Who is the petitioner? Senior counsel, now, then, Nelson Havi. Who did my senior counsel, former president of the Law Society of Kenya, sue? The Director of Public Prosecution as the first respondent. Secondly, the Director of Criminal Investigation as the second respondent, and the Attorney General as the third respondent. What was the facts of this matter? The petitioner, Nelson Havi, now senior counsel, was the president of the Law Society of Kenya, LSK, at that time. There was some leadership wrangles within the Law Society of Kenya. On July 13, 2021, officers from the DCI invaded into Havi's office and whisked him away while attending a virtual court session. Havi was in court, a virtual court session. What did the police do? They came, arrested him, took him to the DCI headquarters. He was isolated in Block B, room number 70. He was neither informed of the reasons for his arrest nor given access to his advocate until after 8 hours, when the officers told him that he was being held for assaulting one Mercy Kalundu Wambua, the then Chief Executive Officer of the Law Society of Kenya, on July 12, 2021. At around 6 p.m., Havi was taken to Ndegwa police station, where he was booked as Ndegwa was booked. this is where now, these are the facts that appeared before Justice Mrima. My President, Senior Counsel, having paragraph 58 says, he was arrested when he was actively involved in handling the public interest litigation against the state, and that at that time of his arrest, he was on his feet representing his clients in the famous BBI case before the Court of Appeal. That the police would not even allow him to conduct the matter first. Everybody knows the BBI was a case being amendment of the Constitution where President Uhuru Kenyatta and the late Prime Minister Raila Odinga were pushing for the amendment of the Constitution. On the other side was William Ruto and his team who were opposing the BBI. This matter started from the High Court, it went to the Court of Appeal, it went to the Supreme Court, where the BBI lost. Havi was on his feet in the Court of Appeal. The police stormed in and arrested him. He tried to tell them, allow me to finish, I'm addressing the Court of Appeal. The DCI could not listen. Why? Orders from above. On paragraph 59, Havi says that a scheme had been hatched that he was to be stopped on his tracks. To him, the police came in handy, hence his arrests. So the judge, according to Havi, because he was representing his clients who were against the BBI, the state ordered his arrest so that he cannot address the court. That is according to Havi. Paragraph 64, Havi says he was in session and sought for some time to complete the session. That was not given. The judge, Justice Mrima, says this court takes judicial notice of the immense public interest that was generated by the famous BBI cases, in which the petitioner, that's Havi, was appearing for some of the parties. By arresting him while he was addressing the court, that was not only dishonorable to the Court of Appeal, but was also meant to derail the hearing of the case. The judge is saying, arresting an advocate while addressing a court is contempt of that court, is showing disrespect to that court. And two, this is true. The state wanted to derail the case. What does the judge talk about court sessions? Court sessions are conducted with a high degree of decorum and in line with the standards of professional practice and ethical practice. So, you cannot attack an advocate while doing his work. The judge says, unless in cases of unprecedented attacks, a police officer intending to arrest any advocate who is in court session must, one, either wait for the counsel, the advocate, to finish conducting his or her matters before that court, or with courtesy, draw the attention of the court to seek the permission of the presiding judge or magistrate of the court to effect the arrest. Otherwise, such disruption may result to a contemptuous conduct of criminal culpability on the part of the police. Section 68, paragraph 68, the judge says, an assault is not among such offenses that are classified as serious crimes. It therefore raises one's antennae, the judge's antennae, for officers from the DCI headquarters to pursue an assault complaint which could ordinarily be handled by even junior officers at the police station. One cannot hesitate to wonder the motive behind this. The judge in paragraph 71 says there was no justification at all to why the petitioner was handled that way. The criminal justice system should never be abused for whatever reasons. It should only be used in the interest of the administration of justice. Using the criminal justice system to settle scores is not in the public interest and must be frowned again. So the judge is saying the police should not be used to settle political scores against Ndegwa Njiru. The police cannot be allowed to be used to arrest senior counsel Havi because he is representing a different issue. And the judge in paragraph 72 wonders, have the police arrested all the goons in this country who are killing people? Have the police arrested the people who are murdering people all over? Femicide is up. The judge asks this rhetorical question. The police should direct their energies and resources to prevention of crime, which we all know is rampant in this country and is about to get out of control. Why do you arrest Ndegwa? His car has broken down. Is that the mandate of the DCI? Is that the mandate of the Inspector General of Police? Yet criminals are all over the country. That is the question Justice Murima posed. The judge says in paragraph 73, it cannot also be normal for the police to be used as agents of injustice on the advocates, since an injustice to one advocate is an injustice to all advocates. Now you know, any injustice to one advocate is an injustice to all advocates. The advocates mean all state councils in the DPP's office, all state councils in the Ethics and Anti-Corruption Commission, all state councils in the Attorney General's office, all advocates in private practice, all advocates who are teaching law in any university, all advocates in commercial entities, any advocate who is an advocate of the Law Society of Kenya, who has an admission number. Any attack on one is an attack on all the advocates. He moves to paragraph 77, which is very, very critical, and says courts must now step up the fight against those officers who, for whatever reasons, choose to act contrary to the Constitution and the law. The consequences of such unconstitutional, illegal, unlawful, and warranted action should no longer end up burdening the state or the institutions for recourse. The fight must be taken to the doorsteps of the individual officers. Oh my God. Justice Murima is saying the fight must be taken to the doorsteps of the individual officers. Previously, the law was this: you sue once an officer of the police or a state officer messes, you sue the AG for compensation. The judge is saying, now sue the individual police officers. What does the judge say? Such officers must bear personal liability. In this case, had the officers who dealt with this matter been enjoined in these proceedings, this court would have made specific findings and orders against them, including bearing the compensatory damages to costs. We have done explainers. In the Mutari matter from Nakuru, the police officers were sued in their personal name. They were quoted in Nakuru, awarded damages of 800,000 shillings to be deducted from their personal accounts. They went to the Court of Appeal. The Court of Appeal dismissed that. Why? The direction the courts are taking is that any misbehavior now by public officers, the public officer will be sued by his name. Our previous court explainers have led to that. What did the judge do? The judge ordered the second and third respondent, that is the government, to pay Nelson Havi Kenya shillings, 5 million shillings as compensation. And the charges that were preferred were set or quashed. What are the lessons in this matter? Ndegwa Njiru was arrested. He will be going to the Constitutional Court. Nelson Havi, senior counsel, you can hear him. He has threatened that he's going to court to represent Ndegwa Njiru. This was compensation. This was compensation as per 2023 of 5 million shillings. 2024, the Ashad case, the Pakistani Ashad case, the compensation went to 10 million. The Supreme Court has confirmed 10 million. Gachagua case, Ndegwa Njiru was an advocate in that case, violation of rights. Gachagua was given 50 million. So if Ndegwa goes, Ndegwa is likely to make 100 million. Because for advocates, it is a court officer. He's not a politician. It does not add mileage to him. It is diminishing the profile of advocates. So from court helicopter, we urge Ndegwa Njiru to proceed to seek for compensation of 100 million from the police officers who arrested him. Our previous explainer, we said we are waiting for the suit of Gachagua to sue senators individually. And our explainer, we said Gachagua is likely to get 600 million if he sues individual senators. Wakili Danstan Omari telling the Kenyans, whenever you have been arrested illegally, sue the police officers in their own name. Whenever land registrar misbehaves with their land, sue him in his name. Whenever you go to a hospital, a public hospital, and doctors don't treat your patient, sue them in their personal name. This is going to be the end of impunity and disregard to the rule of law. Wakili Danstan Omari.